This is a part heard appeal in the matter of Andrew and the Federal Republic of Nigeria.
Yes, Mr.
Lords, I finished yesterday by submitting to you that Article 6 was not engaged at all. And unless your Lordships have any questions on that or the Crown on the application of G case that I handed up,
Yeah.
I was going to...
Well, that really deals with why, I mean, he makes the point, doesn't he, that Fayed was actually a more extreme case where Article 6 didn't apply.
Yes.
You would say, well, that demonstrates the issue.
Yes. Yes. I mean, I have to accept, the reason I handed it up is I have to accept that the question of decisive resolution of a civil right is a pragmatic one. It's not a hard-edged question, but nonetheless, it's quite apparent from that case. In particular, the way it was applied to a situation of factual findings by one body, followed by disciplinary findings by another, that is not going to engage Article 6 in the first stage, largely because the second body has to make its own factual findings and has to make findings as to the consequences of those facts for the legal right, i.e. should there be a striking off. And my Lords, ultimately, we suggest that that is obviously right. It would be highly undesirable if non-party witnesses were afforded the full panoply of rights under Article 6, which are given to those whose legal rights are actually being determined. Where the question is simply one of reputational impact, it's obviously appropriate that is dealt with under Article 8, which has a softer edge requirement, if I can put it that way, because it's not concerned with the determination of rights per se. All I want...
In the context of the court having to make sometimes very serious findings against professional people arises on a pretty frequent basis in these courts, in this building. And the idea that in every single case where somebody gives evidence who's not a party, then there's a sort of panoply of ECHR rights that lead to, which give a right of appeal is slightly concerning.
It would be, my Lord. And of course, not when your Lordship says these courts. Plainly, that's right for the commercial litigation. Very often, professionals, directors are having to be criticised. Equally true, obviously, in the family courts, where many of these cases have arisen, where you have social workers and so on. Equally true, I'd have thought, in the criminal courts, where you may well have issues of exclusion of evidence because a police officer has allegedly misconducted themselves, but you don't give the police officer full Article 6 rights to engage in that process. And if one were to start saying any time where a professional person might be severely criticised gives rise to Article 6 rights, it would, in our submission, place an intolerable burden on the courts to treat every person who might find themselves criticised as effectively being a quasi-party. But Moses, if I'm wrong about that and Article 6 is in play, can I just very briefly make a submission on what that requires by way of reasons? And if I could just take up the decision in English, which is Authorities Bundle B, tab 15, page 347. And it's just a convenient place to find it because this court looked at the Strasbourg jurisprudence, starting at paragraph 8. And really just 2 points I want to take from this. The first is at paragraph 8, you get the quote from Ruiz Torrija in Spain, which makes the point that Article 6 obliges the courts to give reasons for their judgments, but that cannot be understood as requiring a detailed answer to every argument, but the extent of the duty varies according to the nature of the decision. And then over the page at paragraph 12, having surveyed the Strasbourg jurisprudence, the court makes the obviously the correct observation that the ECHR isn't concerned with the merits of the decision, but goes on to say procedure has to be fair. It requires that a judgment contains reasons that are sufficient to demonstrate that the essential issues that have been raised by the parties have been addressed by the domestic court and how those issues have been resolved. And then this, which I rely on, it doesn't seem to us that Strasbourg jurisprudence goes further and requires a judgment to explain why one contention or a piece of evidence has been preferred to another, and then makes the point that the common law judgments tend to be more detailed than civil law judgments. But my lord, really just to make the point that under Article 6, whatever may be the requirements under the common law, no requirement to give detailed reasons under Article 6, and in particular no requirement to explain why an argument or a piece of evidence has been preferred, provided one can see how the essential issues have in fact been resolved. That then takes me to Article 8, and 2 points that I'm going to deal with there. The first is, was it engaged at all? And the second is, does Article 8 offer? Now, as to the first, was it engaged? We of course accept that, as Re W holds, the making by the court of severe criticisms of a professional person which fall in the four corners of the case engages or has the potential to engage at Article 8. But we submit that Article 8 has no application where the court is simply determining issues which fall within the four corners of the case and on which it has heard evidence from the witness. And we say that essentially because there is no Article 8 protection for the foreseeable consequences of one's own actions. And if one chooses to give evidence, it is entirely foreseeable that the court will comment on and decide the matters raised by that evidence, and that simply doesn't engage Article 8. And, my lord, we rely for that proposition on the Del Campo case. That's Authorities Bundle A, tab 13, which page 308, which my learned friend took you to. So this is a case, as he summarised, where there was effectively disciplinary proceedings in which a teacher was found not to have harassed his colleague. The colleague then sues the local government for failing to prevent harassment, and without any notice being given to the teacher of those proceedings, the court finds that the teacher had indeed harassed his colleague, as in finding that the claim against the local government was a good one, and the teacher complains that that breached his Article 8 rights. So a classic no notice type case. But the passage on which we particularly rely is at page 322. And paragraph 41. And the court says it reiterates that Article 8 cannot be relied on in order to complain of a loss of reputation, which is the foreseeable consequence of one's own actions, such as, for example, the commission of a criminal offence. But importantly, the way the court then goes on to look at it in the context of this case is that it's of the opinion that in the instant case, it can reasonably be supposed that the applicant could not have foreseen the consequences that the judgment of the High Court of Justice entailed for him. On the one hand, he was reportedly unaware of the proceedings, he had not been summoned to appear, was not a party, which was solely concerned with the position of the local authority. Further, the complaint lodged against him by his colleague had previously been dismissed and there had been no further action, lays emphasis that the applicant was never charged with or proved to have committed a criminal offence, and it follows that the disclosure of the applicant's identity can't be considered to be a foreseeable consequence of the applicant's own doing. And we suggest that what the court is looking at there, by looking at whether he was aware of the proceedings, is whether it was, in part, foreseeable that the proceedings would result in a finding against him. The position is quite the opposite here. It's entirely foreseeable that if a lawyer receives and retains the other side's privileged documents and then voluntarily chooses to appear for his company, he's the majority owner of the company, in order to defend allegations of impropriety in relation to the other side's privileged documents, it is entirely foreseeable that the court may reject that evidence and make adverse findings about the witness's conduct. And we say that applying the principle in paragraph 41, Mr. Andrew cannot complain that his private life has been invaded by virtue of the foreseeable consequence of coming to a public hearing to assert that he'd done nothing wrong, and the court then disagreed.
Would it make a difference if PID had served a witness summons on Mr. Andrew?
My lord, yes. On this basis, it would make a difference, at least arguably make a difference. And in my submission, that is right as a matter of principle, that where someone is being forced into the situation, they may perhaps be entitled to...
We don't know whether or not a witness summons was served on Mr. Andrew. It may have been.
He provides witness statements, and he does so saying he's been authorised to do so by P&ID. So certainly he's not, a witness summons wouldn't compel him to provide a trial witness statement, for example. It would be a witness summary.
If he was being called under a witness summons, that would have emerged at the outset of his evidence. But in fact, from recollection, I think I'm right in saying Lord Wilson simply tendered him for cross-examination on the basis that his witness statements were his evidence.
He was simply tendered for
So he's
cross-examination.
just a standard witness. There's no suggestion he was under any sort of compulsion.
No.
Given that he was a majority owner, I think, by that stage of the company.
Yes.
It would be rather surprising if he were under.
Yes, and certainly the tenor of the evidence is that he wishes positively to explain why the arbitration award in which he's got a $3 billion interest should be upheld.
Just to follow it through, and certainly in my experience, it's not uncommon that parties will witness summons even their own cooperating witnesses. Not least because if one of them ultimately, for some reason, can't give evidence, it makes it easier to
Yes.
put in their evidence by way of a hearsay notice or whatever. And some might say it's good practice to witness summons your witnesses just in case. And it seems to me it would be odd if that formality of witness summoning a cooperating witness made the difference between whether they did or didn't have Article 8 protection.
Maybe I've slightly overstated it. The way I would put it is to say there can't be any Article 8 rights for someone who voluntarily appears because it is simply the foreseeable consequence of their own actions. Where they've been summoned, there may be a question as to whether Article 8 is engaged. Is it a consequence of their own action, or is it something where they're under genuine compulsion? And in my estimation, that is a sensible divide in that the court perhaps does have an interest in protecting those who've not chosen to expose themselves to a risk of adverse findings. Equally, and it's the point made in Re-W, the position of a person who is not a witness, who does not appear at the hearing, may be different to the person who is a witness and does appear. Because again, the known consequences of the actions are different. But certainly the line we draw is that once you have a witness who voluntarily appears to defend their conduct, they simply cannot complain of the foreseeable consequence that the court may disagree with them. And again, we submit that's a sensible conclusion, because it would be a highly undesirable thing if the court had to start giving witnesses protections against the natural consequences of their own decision to give evidence. That's not the court's role. Now, if Article 8 is engaged at all, what is its scope? What protections does it require? Well, certainly it does have a procedural aspect, but as I made the point yesterday, one does have to keep firmly in mind that Article 8 is not limited to judicial proceedings, and therefore, in my submission, the court has to be careful not to read judicial type protections into Article 8. We submit that all that Article 8 provides is a right to make meaningful representations before a decision is taken. And therefore, in the context of a non-party witness, that means that they must know the gist of what is being alleged against them, and they must be given some opportunity to provide their response. Not the full opportunity that a party would have, but a sufficient opportunity to do so. And we submit, on the other hand, there is no reason why it should include a right to detailed reasons for any criticism that the court chooses to make of that witness. This ultimately, we're talking here about non-parties who don't have rights of appeal on the substance, and therefore they simply don't have need for reasons in the way that a party does. And really, two cases on the scope of Article 8. Re W is the one of the leading cases. That's an authorities bundle D, tab 46. And starting at page 1187, obviously this was a truly exceptional case where the criticisms were made with absolutely no notice to anybody beforehand. But the Lord Justice McFarlane in paragraph 94 goes on to give short observations, as he puts it, on what the judge should have done. And paragraph 95 makes clear that the focus is very much the risk of adverse findings of significance outside the known parameters of the case. So again, the focus is very much on matters which are not squarely in play, which we say fits with the submission I've just made. But even then, all that is required is that consideration is given to three matters. It's not even saying that there's a right to those things, but consideration is given to ensuring that the case is adequately put, prior notice of the case, including access to documents with sufficient time to review them, and investigating the need for, and if there is a need, the provision of adequate legal advice supporting court, and so on. So these are are relatively low level requirements. The court simply consider what is necessary to ensure that the non-party witness has a fair opportunity to address the criticism that is being made against them. And one can see how that then plays out over the page at 1188, paragraph 98. About halfway down that paragraph, judgment should be seen by the profession and the family judiciary to be a particular bespoke response to a highly unusual combination of factors. So A is the fact that it's outside, A is the fact that they are serious criticisms. B is the fact that they play no part in the case presented by any party. And C is the fact that they've not been raised. So again, very much focusing the entire REW jurisdiction on serious criticisms that are not within the scope of the proceedings themselves, and of which there is no notice. It's not this broader right to reasons and so on.
Well, that was exactly the point that was picked up by the Court of Appeal in Gray.
Yes.
In the context of W.
Yes.
Contrasting the position in Gray with the position in REW.
Yes, Mark.
And you would say, presumably, position in the present case is equally to be contrasted because those three conditions, one way or another, have been, three considerations have been taken into account.
Yes, my lord. And yes, we do. And more widely, we submit that it does demonstrate the limits of this jurisdiction. It is truly for the exceptional case where something very serious is being raised that is not within the scope of the litigate, within the case as it's being argued.
The points about the coming voluntarily, not being summoned to be there, Article 8 not engaged, you say, and the points about being within the four corners of the matters and on notice. Are you saying that either of those, if either of those, sorry, it's only if they're not, only if they've been summoned and it's outside the four corners, so that Article 8's engaged?
My lord, I see the 2 points as interacting in that, in reality, if it's within the four corners of the case, it's going to be a foreseeable consequence of giving evidence in that situation that you are at risk of criticism. But if a witness were summoned, again, my submission would be potentially Article 8 could be engaged, but there's never going to be a breach of it if the matters that are then put to the witness are ones that they've been given notice of, they've been given access to the documents and so on.
Forgive me, but there's no suggestion, is there, that the social worker and the police officer in Ray W have been summoned?
There's not.
So why don't you simply say it's not engaged? Article 8.
Well, my lord, and that was a point raised in Bore, that Lady Justice Gloucester recognises that there was a concession in Gray that Article 8 was engaged, and says that she hadn't heard any argument to the contrary. And indeed, my submission would be that in Re W, the answer is that it was not a foreseeable consequence of being engaged in that litigation that there would be these findings, because those allegations weren't part of the proceedings. So if you apply the Del Campo test, was it a foreseeable consequence of giving evidence in those proceedings that there would be a finding that you'd conspired to harm the child? The answer is no.
I see.
And so Article 8 is engaged. And my lord, as I say, there's a simple answer to this case, which is even if Article 8 is engaged, it's within the four corners of the case. There's no unfairness.
Well, that's the point, isn't it? It's really the point that derives from the Court of Appeal in Gray. Assuming Article 8 is engaged,
it is.
I mean, whether you're right or wrong about that, then there's no question of the rights under Article 8 being infringed by reason of the three considerations having been taken into account.
There's certainly no question of the right being infringed, and in a sense, it might be said gilding the lily, but it is my submission that actually, when one analyses it properly, Article 8 is simply not engaged on the foreseeable consequences test in this case. That wouldn't be the case in Re W, because it wasn't at all foreseeable that if you turn up and give evidence in those proceedings that you would be criticised in this way, whereas it is entirely foreseeable that if you turn up in front of Mr. Justice Robin Knowles, that you may well be criticised.
Okay.
And my lord, that contrasts just on the scope of Article 8. If you go on to page 1189, paragraph 101, the judge, Lord Justice McFarlane, is making the point that there will essentially not be any need to change the general approach to witnesses. You see that at the end of paragraph 101. I'm attempting to attach this judgment as to the highly unusual circumstances of this case, and the absence of any need, as I see it, for the profession and judges to do anything to alter the approach to witnesses in general and expert witnesses in particular. And because the judge is making the point earlier in that paragraph, that it will be very rare for a witness's fair trial rights to be at risk so as to need any additional process, because they will inevitably have had access to documents. The case being put will be within the four corners of the case, and they will have been cross-examined. And so the trial process in and of itself will provide sufficient protections for witnesses where the allegations being dealt with are within the four corners of the case.
The fact that Lord Justice McFarlane thought that Article 8 may apply in principle even to expert witnesses, but that it would be very rare that they will be breached, that indicates that Article 8 rights are engaged and possibly always engaged, but that they will not be often breached.
It does. I accept that that is the logic of this judgment, but it doesn't appear to have been argued here that the Article 8 rights are not engaged or are not available to a person in respect of the foreseeable consequences of their own actions.
And once you start talking about rights, about not having an Article 8 right, that becomes quite difficult. And it's because we all have our Article 8 rights all the time. And to say that someone doesn't have Article 8 rights in a particular situation, rather than that there is no possibility of them being breached by this situation, seems to me to be quite difficult.
Well, my lord, of course, everyone has Article 8 rights all the time. One has a right to a private life. Equally, if one chooses to go public about matters, you still have your Article 8 rights. It's just you've got nothing to complain about because you've brought the breach upon yourself.
I just wonder if it's helpful to talk about Article 8 not being engaged rather than Article 8 there being no possibility of Article 8 rights being breached.
I mean, the way I put it, and whether engaged is the right language, is that a witness can't rely on Article 8 in respect of foreseeable consequences of giving evidence.
Yeah, well, I think that's what Lord Justice McFarlane is saying, really, isn't he? He's saying it may in principle apply, but there's no possibility of it being breached.
It may come to much the same thing, that either inevitably there won't be a breach, or there's simply no right.
I'm just a bit concerned about drawing bright lines dependent upon whether somebody has been witness summoned or whatever. It seems to me quite a stark approach, a much more nuanced jurisprudence.
My lord, I follow that, and as I say, it's unnecessary in this case to go that far anyway. But I do submit it does follow logically from the ECHR jurisprudence that it is, in fact, impossible to envisage a situation where a witness who has chosen to give evidence, and all the judge has done is make findings in relation to that evidence, having had her Article 8 rights breached, because that is a consequence of the process of giving evidence.
But that's why I think the point about whether or not the witness is giving evidence voluntarily may be a bit of a red herring in one sense. If we go back to his three considerations and look at them in the context of a witness who is giving evidence, whether it's pursuant to a witness summons, therefore under compulsion or not, but where the evidence that the witness is giving is within the four corners of the case.
Yes.
And if you look at the three considerations, first of all, ensuring the case in support of such adverse findings is adequately put to the relevant witness. Well, if the witness is somebody, whether it's an expert or a factual witness, as in this case, who's had access to pleadings where allegations against him are actually made, is then cross-examined uphill and down dale for 3 days on those allegations, then A is clearly satisfied, prior to the case being put in cross-examination, providing disclosure of all the relevant documents. Well, there's no suggestion here
No.
that Mr. Andrew didn't have access to all the documents that he could possibly want to have access to for the purposes of giving his evidence. And C, investigating the need for support in court or representation, adequate legal advice, and so forth. Well, true it is the judge didn't say to him before he was cross-examined, you know, you might want to take your own legal advice. But two things about that. One, he's a solicitor anyway. And I mean, there's a limit. It's not like a litigant in person who has no legal qualifications. And secondly, we know that in fact, he had already, I think he had already at that stage, before this trial, taken advice from Mr. Treverton Jones.
Yes, he says in terms that he took advice from the stage of the Ross Cranston hearing, and thereafter on a number of occasions, including I think when the case was amended, and of course one of the amendments was to include the privileged documents allegations. Well, my lord, I'm not, as I say, I've raised the point by reference to Del Campo about foreseeable consequences, but it's certainly not necessary in this case to go that far, and it may be they ultimately point in the same direction, in that whenever a witness turns up in court, they will know what's going on, and it's foreseeable what will happen. The other case, just on the scope of Article 8, is the Tabac case, which is also in Authorities Bundle D, tab 41, page 1062, and it's a case referred to in Read W. And really, just to take from it, if you go on please to page 1080, case of Mr. Justice Cranston, as he then was, in the context, I think, of setting licence conditions for prisoners on determinate sentences, paragraph 58 sets out the requirement that the decision-making process, when considered as a whole, and I emphasise when considered as a whole because that's quite important when we're looking at the failure to take advantage of the opportunities afforded to Mr. Andrew, that the process as a whole must be fair and be such as to afford due respect to the interests safeguarded by Article 8. But if one goes on to paragraph 59, it's been looked at as a principle of effective participation in the decision-making process. Paragraph 60 then refers to the decision in BB. Halfway down the paragraph, it's identified that what fairness very often requires is an opportunity to make representations, and for that purpose, Lord Mustell added, knowing what factors may weigh against his interests, therefore being informed of the gist of the case to be answered. So Article 8 very much looked at as an effective participation.
Just sort of thinking about it generally, if you think about a witness who is somebody, a party calls a witness, like in this case Mr. Andrew, who you know is going to be criticised because there's a pleaded case of raising a series of criticisms. That witness is, in fact, isn't, as it were, well, I suppose there are situations where the witness might be thrown to the wolves after his or her evidence, but usually the party who's called the witness will then be making submissions to the judge in closing as to why he or she should accept that witness's evidence and why the criticisms that are made of that witness are not justified criticisms.
Yes.
So in that sense, the protections that Lord Justice McFarlane is talking about are subsumed within the trial process.
My lord, yes. Although I would submit that one doesn't even need to go that far, in that if it's been put to the witness they are lying, or it's been put to the witness that they behave dishonestly, the witness will have said what they want to say, the judge will have heard it, and that is sufficient to satisfy the right to effective participation. The decision maker has heard what the affected person wants to say about it. the fact that there then may be counsel subsequently arguing for the veracity of that position is,
Well, no, I
is
think
nice
the point
to
I'm
have.
making is the point that, if you like, it's an extra layer of protection.
It is. It is an extra layer of protection, but not in my submission.
And in a sense, that
necessary.
addresses the point that, you know, would it be necessary for a witness in that situation to get separate legal advice? We wouldn't.
Yes.
You know, one of the things that, sort of thinking about the wider implications of all this, that certainly concerns me, is the idea that you have a try and start arrangement during the course of trials where there often are criticisms made of witnesses, and the witnesses stop, you know, I need to take legal advice on this. Well,
Yes.
that's just not how our system works.
No, and indeed couldn't work if that's what happened.
And obviously there are issues about, you know, the privilege against self-incrimination and that sort of thing. But except in that scenario,
Yes.
the idea that somebody's got a sort of his lawyer watching every move is, I mean, I know there are, I mean, I can remember doing a case at first instance where somebody did have a member of the bar representing him during course of his evidence.
Yes. Well, I can say exceptionally, I cross-examined recently a forensic accountant who we discovered had, shortly before the hearing, was subject to criminal investigation for fraud. And he did bring along a member of the bar in case any issues arose that needed to be addressed. And there may be exceptional circumstances where that arises. I mean, plainly, one of the points Mr. Andrew makes here is that, to an extent, he was thrown to the wolves in closing because P&ID accepted questions as to his professional conduct rather than outright trying to defend him. But my primary submission to that is going to be he'd had an opportunity to say what he wanted to say, the judge had heard what he wanted to say and no doubt bore that in mind. But in any event, he's a professional person, he knew what P&ID was saying in closing, and if he thought there was something important that the judge needed to hear that wasn't being put by a party, he could have taken steps, and he didn't need the judge to babysit him effectively and tell him the risks that the judge would find, indeed, that his conduct was indefensible because no one could defend it. But Mo, I've raised that now just to say obviously I wouldn't want to accept, and I'd submit is wrong, is that there's any need under Article 8 that the party's counsel is defending the witness's integrity. Maybe there are cases where that would raise an issue where the judge needed to stop and think, but it certainly doesn't follow that there must always be counsel effectively representing the witness's interests.
Well, there's no property in a witness and no obligation to defend any particular witness.
No.
And also when it's also clear, as my lord says, that a judge may be under an obligation to warn a witness about the risk of self-incrimination, and they're not obliged to answer. But there's no suggestion that the follow-up to that, if they do choose to give evidence on the point, is that they should be represented.
No.
Or have any right to make representation.
No. My lord, yes. And equally, my lords, can I just make the point about reasons under Article 8? I mean, it may very well be that a judge decides to deal with a witness's evidence very briefly. I mean, for instance, the judge may say, I found Mr. X wholly evasive and I'm placing no weight on anything he says. The idea that Article 8 requires some detailed analysis as to specific examples where he was found to be evasive is, in my submission, wholly unrealistic. It's not what Article 8 requires for the witness to have a right of effective participation before that criticism is made. And again, it would be an unworkable burden on judges who, having heard the trial, may well know they can deal with that witness and that evidence very briefly for the purposes of resolving the case in front of them. And the point made in Tabak, in paragraph 64, 4 lines down, in the context here, of course, of fixing an offender's licence conditions, is what's required an assessment of the nature and practical effect of the rights in each case. But the requisite procedural rights are the very basic the law requires, so the offender is able to make meaningful representations. So really a strong emphasis on Article 8 rights in this context being very limited. They are the very basic you need to have made meaningful representations. And that really doesn't require detailed reasons, access to counsel, or anything of that sort. And indeed, in that case in particular, I accept a very different context. It was found that the Article 8 rights were satisfactorily met by the probation officer being able to feed in the offender's perspective to the relevant meetings. So it really is a very basic right to make sure your voice is somehow heard, but nothing more than that. So, my lord, that's what we say about Article 8, a very basic right, plainly not engaged in this, plainly not at risk of being breached in this case, given that Mr. Andrew knew precisely what was being alleged and had a very full opportunity to deal with it. Let me then deal briefly with what actually happened at the trial, and I appreciate my lords are very familiar with it, so I'm just going to highlight some key points. Obviously, a few points about Mr. Andrew himself. The first point, of course, is that Mr. Andrew, like Mr. Gray in the Bore case, was extremely close to the litigation and had full knowledge of everything that was happening in real time. Very unlike the social officer or police in Re W. He'd obviously been counsel in the underlying arbitration, so knew what had happened there. He was a director and indeed the majority economic shareholder of P&ID throughout the High Court proceedings. And on any view, he was one of the people most closely involved in the conduct of the High Court proceedings. Now, there's a debate about whether he had control or could be outvoted by VR Capital's representatives, but frankly, it doesn't matter for present purposes. What matters is that he clearly was inside and knew precisely what was going on in the litigation. He saw the pleadings, he saw the written submissions, he was present through the majority of the trial. He accepted in cross that important questions in the litigation were put to both him and VR Capital. He accepts that he discussed the law and facts with P&ID's lawyers. He saw the draft judgment, so he knows in real time what is happening and what decisions are being taken. Secondly, he's a qualified solicitor and barrister with, in his own words, extensive experience of international high-value commercial disputes. The court was entitled to consider that he understood the risks of litigation and he understood how to protect his own interests if that became necessary. And the third point about Mr. Andrew is that he was in fact advised personally throughout the proceedings, including after the receipt of the draft judgment by leading counsel who was specialising in professional conduct matters. So on any view, the sort of person who is very, very unlikely to need Article 8 protections.
Well, he also had the draft judgment, as did his advisor, so for a week before it was handed down.
He did.
So he had every opportunity to make representations.
He did. In full knowledge of precisely what was going to be said. And certainly one of my submissions, although we say you don't get here, is that even if there were any problems earlier on in the process, when one looks at the process as a whole, as the authorities say you must, it was plainly fair because Mr. Andrew had an opportunity to deal with those matters before the trial judge, rather than sitting on his hands and jumping up in this court and saying, oh, you need to put it all right. Or not even you need to put it right, you just need to expunge the findings and start editing the judgment. My lord, then in terms of the case put, I mean, your lordships are well aware that this was squarely part of the claimant's case. I say this, the improper handling of privileged documents. Mr. Andrew's role in that had been pleaded from the particulars of claim. But if it were in any doubt, the granularity given in the reply could have left Mr. Andrew in no doubt. Can I just show your lordships that? It's core bundle B. Tab 17,
Yeah.
page 505.
Tab 17, page 505.
Tab 505. So this is in our reply. And one can see it's subparagraph 4 that we are putting the case that it's obvious from the face of the FRM privileged documents that they're privileged. And in subparagraph 5, we refer to Mr. Andrew as an experienced lawyer and say it would have been obvious to any reasonable lawyer that the FRM privileged documents were privileged and or confidential, and that they had been improperly retained. So squarely putting that Mr. Andrew must have known. And then if one goes over, please, to page 506, paragraph 37E, there is actually a whole section, a whole paragraph that deals with the position of the legal representatives, Mr. Andrew and Mr. Burke. And in particular, if you please turn over to page 507, subparagraph 5 is dealing with financial interest. And you will see the allegation at the end of that paragraph is that both individuals therefore have and had a very substantial interest in the outcome of the arbitration and the litigation. But the reference to the arbitration is important because there's a suggestion that there was some unfairness in finding that there was financial motivation at the time of the arbitration rather than only subsequently. But that had always been squarely pleaded. Now, it's right to say that the basis pleaded there.
It was put pretty early on in the cross-examination on Mr. Howard. There was a quite a long discussion between him and Mr. Andrew about what had been promised or what had been spoken about, whether it was 10% or 12.5% or 25%. But never mind the detail. But the fact is that was fairly and squarely put to him.
It was.
That he'd always had a financial interest.
It was.
At all relevant times.
And well, the way it played out was that this was pleaded. Mr. Andrew plainly understood his interest at the time of the arbitration was in play because he addressed it in his witness statement. Didn't just come up in cross by surprise. He had positively dealt with that in his witness statement for trial, and then he's cross-examined on it. But that allegation of financial interest at the time of the arbitration was not something surprising to Mr. Andrew. And then over the page at 508, you have the clearest possible allegation at subparagraph 5.
Sorry, subparagraph.
Subparagraph 7, I apologise.
7, yeah.
Of breach of professional and or legal duties by not returning the documents or ceasing to act if the client refused and notifying the tribunal. And then I just draw attention to subparagraph 8 because my learned friend suggested in the context of the corruption finding that wasn't open to the judge because it was never suggested that Mr. Andrew had used the documents. But you will see at subparagraph 8, it's squarely pleaded, contrary to their professional and or legal duties, Messrs. Andrew and Burke made positive use of the privileged documents. And indeed, then in the subparagraph 1, an example is given where Mr. Burke, Queen's Counsel, asked Mr. Andrew to call me when he was forwarding a particular document, and it suggested that it's to be inferred that that call took place. And indeed, there was cross-examination to the effect that that call must have taken place. So I was just pausing there. Nobody who received the pleadings could have been in any doubt of the seriousness of the allegations being put against Mr. Andrew. It was a deliberate breach of professional duties, knowing that these were documents in which, on their face, were privileged and improperly obtained, in circumstances where he had a very significant financial interest. I should say before trial there was also served what's called a statement of facts, which set out every document, every privileged document relied upon, and identified every privileged document that it could be shown that Mr. Andrew had received.
Is that in the bundles?
It is, so it's core supplementary bundle, tab 17, page 287.
(287).
287, yes. And you should see statement of facts and documents pursuant to section J8.6 of the Commercial Court Guide. And to take an example, if you go, for instance, to page 323, paragraph 40 is a reference to a document in which the Ministry of Petroleum's in-house lawyer is instructing leading counsel, Mr. Chancellor, to offer a figure of 400 million, negotiate a figure below 500 million, and you can see at subparagraph 1, there's a reference to it being sent on to Mr. Andrew, and at subparagraph 4, there's a reference to Mr. Andrew's purported explanation for that, that it was provided voluntarily. So each of the documents was listed out, and Mr. Andrew would have accepted in cross-examination that he'd read this document and would no doubt have seen every time it was being said that he had received a document. Yes, yes. So Mr. Andrew, in fact, had very granular detail about all the documents that were going to be put to him in cross-examination.
And he was cross-examined about this as well.
He was cross-examined in the cross-examination. So this, you mean this particular document?
This particular document.
He was cross-examined about many of the documents.
Yeah.
I mean, there's essentially almost a whole day of going through particular documents, and he was certainly cross-examined about this one. Mullers, while you have this bundle to hand, if you go back, please, to tab 13, you have our opening submissions.
13.
Tab 13 of the core supplementary bundle, and I can take it from page 227. And you see at paragraph 424, about 4 lines down, Mr. Andrew is specifically identified as someone involved in the receipt of documents on behalf of P&ID. It said it will be explored at trial, the idea that they lacked knowledge of the circumstances in which they were obtained. It said that that beggars belief. Over the page at 228, it said at paragraph 426 that those acting on behalf of P&ID, which obviously includes Mr. Andrew, were well aware that the privileged content was being illicitly obtained. Over the page at 229, paragraph 430, it's said that simply looking at the content of the documents, it's not a borderline judgment call, they're paradigm examples of privileged documents which must have been obvious to P&ID. And about halfway down, it said it must have been clear to all those acting on behalf of P&ID, obviously includes Mr. Andrew, that they're not being lawfully provided.
Sorry, where's that?
So paragraph 430,
Yeah.
about 1, 2, 3, 4, 5, 6
Must
lines
be clear
down,
to those acting.
was such that it must have been clear to all those acting that it was not being lawfully provided.
Well, that one we just looked at is a classic example, isn't it?
It is.
If you're internally saying, offer them 400 and you can go up to 500, which is effectively what was being said.
Yes.
You don't then show that to the other side, because the first thing that will happen is they'll say, well, then he settled for 500.
Well, my lord, you have predicted a submission I was going to make, which was to show your lordship's two documents, that being one of them,
Yeah.
to say that once you know what the documents were, and then you read the judge's conclusion that no one looking at them could have thought that they'd been properly provided. It's blindingly obvious what the judge is saying. He's saying you just look at some of these documents and no sane human being.
You certainly wouldn't provide them for the purposes of making a settlement. I mean, well, you would in the sense that what you get as a settlement wasn't in your client's best interests.
My lord,
P&ID's best interests.
precisely.
Sorry,
of course, that's exactly what
Nigeria's best interests.
exactly what happens. The 400 offer goes over, and it's immediately rejected in knowledge, as Mr. Andrew accepted in cross-examination, that it certainly wasn't their best offer.
Yeah.
And indeed, I'm reminded, well, two things to say, and maybe I skipped this part of the submissions. One is that Mr. Andrew's explanation for this, which was so obviously incredible, it barely needed to be cross-examined on, was that this was a way of conveying the offer more quickly. When, of course, what happens is the same day, an email goes directly to Mr. Andrew making the offer of 500 million, and making the offer of 400 million.
Yeah.
And of course, the idea that a lawyer thought that it was quicker to sacrifice your client's interest by revealing a higher authority than simply to type into a message, we're making an offer of $400 million, is ludicrous, to put it kindly. And of course, Mr. Andrew himself rejects the offer in knowledge that it's not the best offer. And it goes back to a point I think that's my Lord Justice Phillips was making yesterday, which is this idea of use is completely nonsensical. If he's reading the documents and he has knowledge of Nigeria's internal thinking, he can't help but use the documents. How can you possibly conduct settlement negotiations where you know what the other side is thinking without being influenced by that knowledge? And so it's wholly unsurprising that the judge found that P&ID used the documents to monitor the other side's strategy and settlement. Just finishing on the openings, if you go please to page 230, you will see there, paragraph 434, the specific reference to the rather unfortunate incident where Mr. Andrew is helping to conceal the documents that were unofficially obtained from the tribunal by getting information as to which were official and which were unofficial. And then going on, please, to page 231, paragraph 436, you get squarely alleged the allegation of breach of duty by the legal representative's failure to reveal the fact of what was going on. And you see about halfway down that paragraph, but in any event, the brazen suggestion that P&ID and its legal representatives could decline to disclose to, and indeed consciously take steps to withhold from, FRN and the tribunal, that P&ID was in possession of illicitly obtained documents belonging to FRN is remarkable. And indeed, then there's in footnotes 989 and 990 over the page on 232, there is reference both to the legal duties in Arbely and LNK and to the professional duties, including, of course, what we now call the core duties, what were then the fundamental duties, to act with integrity and honesty and not in a way that will undermine the administration of justice. I'm not going to go to it, but unsurprisingly, the oral openings by Mr. Howard were trenchant in their criticisms of Mr. Andrew. It was said that the court would have to consider whether his behaviour was appropriate. reference was made to the fact that he was in it for hundreds of millions of dollars, and it was said that nobody could think that they had the right to see these documents, and that the explanations being put forward were, quote, a fake construct. So no doubt that Mr. Andrew knew that it was going to be said that his explanations were lies. Certainly the gist of the allegations was more than sufficiently notified to Mr. Andrew. Similarly, he not only had but took the opportunity to answer those allegations. He gave a lengthy witness statement for trial. That's in supplemental reference bundle A, tab 3, starting at page 58.
Sorry, give me the reference again.
Supplemental reference bundle A, tab 3, page 58. And if you go, for instance, to page 63, you'll see at paragraph 26, which is a point I made to the Lord the Chancellor earlier, that Mr. Andrew was well aware that his financial interest was in play, because he's dealing in paragraph 26 with what his interest was during the course of the arbitration, and you'll see at the end of that paragraph he specifically refers to the fact that it was being suggested to him that he would get a percentage of the proceeds, and that's of course what leads then to the cross-examination that it was never suggested it would be less than 10%, and the figures ranged up to 25%. I should say, of course, that's one of the matters that the judge has referred Mr. Andrew to the regulatory authorities in respect of. One might think that for someone to be appearing as counsel on the basis that they are being told they might receive hundreds of millions of dollars, but it's entirely at the whim of their client, is the classic example of how a lawyer should not be retained, because it obviously exposes them to conflicts of interest. They are simply, the client is potentially going to reward them with hundreds of millions, depending on whether they like how they've conducted themselves. But that's, as the judge said, a matter for the regulator. I should say, in my submission, that very nicely demonstrates the restraint the judge applied. There were many, many things in this case that the judge could have said about Mr. Andrew. There were other...
He makes that point, doesn't he, at some point? There were a lot of other allegations which he doesn't deal with. He
does, and he was very acutely aware of the four corners of the case, and that is another indication that we are nowhere near the re-W type situation. Going on then to page 73 of his witness statement, paragraph 60. Again, clear that Mr. Andrew was explaining his purported basis for receiving the document, such as it was. So you see, for instance, he says, I did ask on one or two occasions who was continuing to provide internal documents during the arbitration. Mr. Cahill and Mr. Adebayo assured me there was nothing untoward about it, although they didn't tell me who was providing them. Other than that, I didn't give the subject much thought. And perhaps again, unsurprising why, in light of that evidence, the judge thought the conduct was indefensible. But certainly Mr. Andrew was answering the allegations. And at page 74, paragraph 63 and 64, Mr. Andrew is squarely addressing the allegation of breach of duty. He sets it out extensively at paragraph 63, and then at paragraph 64 he says, I don't agree that I was either entitled or obliged to take any of those steps. But importantly this, given the context in which I received the internal FRN documents referred to above, I didn't believe, let alone know, that the documents had been obtained unlawfully. Rather, I understood there was a practice, essentially, of providing them. In those circumstances, I didn't feel I was obliged or even entitled to reveal they'd been sent. Now, the reason I emphasise that is it was not Mr. Andrews' own evidence before Mr. Justice Robin Knowles that if he had believed they had been illegitimately provided, he would have been entitled to do nothing as he did. So once the judge had rejected the suggestion that Mr. Andrew believed there was a legitimate reason for having the documents, a finding that the behaviour was indefensible was inevitable on Mr. Andrews' own evidence. It was Mr. Andrews' defence was, I had this belief. And the judge said, no, you didn't. Now, my lords, I would say that simply having the opportunity to provide such a detailed evidence would have satisfied the requirements of Article 8. But of course, your lordships know that that wasn't the end of it. Mr. Andrew had the opportunity to give evidence and was cross-examined for 2.5 days, the majority of which was spent on the Nigeria's privileged documents. And of course, nobody suggested during that cross-examination that the case being put was beyond the pleaded case, or that it was otherwise an unfair ambush or anything of that sort. I just want to show your lordships a little of the cross, just to show that these really allegations were very fairly and squarely put. If I could, in the core supplemental bundle, starting at tab 7, and
the decks.
yes, sorry, I've referred to. Core supplemental bundle, tab 7, page 63. So it's the start of day 3, and the start, therefore, of the cross-examination.
Page 63.
63 is the header, and I'm going to start at page 66. Obviously, there is a vast amount of material. I'm not going to try and show you, lordships, all of it. And you might say there is an inherent improbability in the suggestion that Mr. Howard did not squarely put allegations of dishonesty. It's not Mr. Howard's style to pull his punches. But one will see that indeed he did fairly and squarely put the points. So page 66 of the bundle, this is just showing you first that the points about financial interest were very fully explored. And you'll see, for instance, at the internal page 9, lines 1 to 9, one of the matters that's perhaps particularly extraordinary is, as well as Mr. Andrew having dedicated a significant portion of his professional time to running the arbitration, it turned out that he was in fact meeting disbursements as well out of his own pocket. So you'll see that until external funding was obtained in late 2015, that he was paying the fees of the solicitors on the record, Harker Sinclair, and certain other expenses out of his own office account. So for 2-3 years of the arbitration, Mr. Andrew was in fact funding disbursements, and one might think you don't do that without an expectation of reward.
And that comment, well, it is a comment, at the beginning of Mr. Howard's question at the top of page 9 about fencing about silly points, that's in reference to the previous answer, which suggested that he wasn't paying it, it was being paid out of his firm's office account.
Yes, and there was a degree of this, and when one sees it, there's a bit of cross that my learned friends like, where Mr. Andrew says, I don't understand the allegations against me. When one actually looks at that, he's making a fairly silly point about it being a case against P&ID, not a case against Mr. Andrew. It's the sort of points that were being taken. Page 10 of the internal transcript, squarely put at line 21, let's cut to the chase, Mr. Andrew. The understanding from the outset was that you and Mr. Burt would receive payment out of the proceeds of the award. And a long answer is given to that. But indeed, if one looks at the top of page 11, it said it was envisaged at the time, certainly by me, but I also believe by Mr. Quinn and Mr. Cahill, that there would be a funding agreement between Lismore Capital and P&ID, and indeed some documents are drawn up to that effect in summer of 2014. So even on Mr. Andrew's own evidence, when he's receiving a lot of these privileged documents in 2013 and 2014, he is expecting that he will become the funder and that he will therefore get a share of the recoveries. This wasn't some controversial issue in the...
Lismore was his company.
Lismore was wholly owned, and I think he was the sole director. It wasn't some controversial issue that the judge needed to opine on whether Mr. Andrew hoped to make money. He obviously hoped to make money during the arbitration. Similarly, bottom of page 12, line 21, I did hear talk during the course of the arbitration from Mr. Quinn and Mr. Cahill that because of the work that we'd done on the case and the efforts that we made to progress it, they would be minded, if we were successful, to make some sort of payment to us in recognition of that. Although one of his refrains, he says he didn't take that very seriously, although you might think he took it fairly seriously given the amount of time he was dedicating to the case and the fact he was funding the disbursements. But there's then discussion, page 13, bottom of the page, about the percentages, 10%, 25%. And the bottom line here, if you go to page 16 of the internals, even on Mr. Andrews' own evidence, line 12, I thought that if we carried on doing the arbitration for free and we won, they would certainly make a generous payment to his company and to Mr. Burke. I always thought that. So there just wasn't really an issue that Mr. Andrew hoped to make a significant amount of money from the arbitration. And so it's, when one sees criticism of the judge's reasoning about financial motivation, it really wasn't a matter that, in terms of the extent of the interest, really wasn't something that was being hotly disputed. It was also put that there was a link between the interest, the financial interest, and the interest in the documents. Just to show you, Lordships, that tab 8, page 125.
Tab 8.
Yeah, tab 8. So it's the next
day,
page 125, and this is being done in the context of a particular document. But you'll see internal page 66. Line 17, the truth of the matter is, in relation to this, you and Mr. Burke were working in the expectation of a share of the proceeds, or at the very least knowing payment was likely to be conditional on success against FRN, and you would have been acutely interested whenever these internal documents were sent to you as to what the FRN knew and were being advised in the arbitration. That is actually the true position. So again, no doubt that Mr. Howard was putting the connection between interest in the documents and financial interest in...
And clearly challenging the suggestion that he, which again, as you say, is part of the refrain, that he may have had the documents but didn't actually make any use of them or read them or pay attention to them.
Yes. Yes, I mean, that's squarely, the theory being put there is because he's got a financial interest in the arbitration winning, he's looking at the documents. And this was being asked in the context of a document that revealed evidence gathering in relation to the potential defences before the statement of defence had been filed.
We'd also told them that Nigeria wasn't aware that Mrs. Tager was being bribed.
My Lord, that is right, but my learned friend is right to say that the judge did not find that at the time of the arbitration, Mr. Andrew knew that. So he wouldn't have, on the judge's findings, it can't be said that he would have had an incentive to monitor that beyond the general incentive, the general use referred to by the judge, which is generally monitoring the strategy and defences that the other side were going to run.
Yeah, it's a general monitoring point, isn't it? Because obviously if that was something of which they were aware, then Mr. Andrew and others would have become aware of that themselves, and it would no doubt have influenced the way in which they conducted the arbitration.
One just has to posit the example. I mean, say that the document about lines of defence had said we should look at whether Ms. Tiger was getting any money. And obviously at that stage, Mr. Andrew, with that knowledge, couldn't help but think, well, is that going to affect the merit? Should we try and get a settlement done quickly? And plainly, having access to advanced knowledge of what your opponent is looking at, what evidence gathering they're doing, is inherently gives you a strategic advantage. And that's, of course, the reason we have privilege, because that's an advantage that should not be available. So, my lord, no doubt the financial interest issues were squarely put. Equally, no doubt that the allegations about knowledge that the documents were not being legitimately provided was put. It was put both thematically and it was put by reference to individual documents. To take an example of the thematic challenge, if you go on, please, to page 130 of the bundle,
The same.
it's same day, internal page 86. You'll see at page 86, line 10, over this period of years, there's not a single documented communication, other than that email you've referred to, where anyone from PNID explains the position to you, or you ask them a question, or you even note down for the file the position. Complete absence of anything, isn't there? So this is asking about why there aren't any notes or records of where the documents were coming from. Mr. Andrew, yes. And Mr. Andrew, the reason there is a complete absence is that you knew full well throughout that these were being improperly obtained, and that is why there is nothing to explain the position in your file, and he denies that. But plainly, a thematic point being put, a lawyer who's getting privileged documents would make a note of their thinking. You didn't note anything down because you already knew it was totally dodgy. In terms of the document by document challenges, I was just going to show your lordships two documents and the cross-examination on them, really just to show that these points were fully explored and that to give context to the judge's finding that no one who saw them could have thought they were being provided voluntarily. If you'd keep the core supplemental bundle to hand, but take out supplemental reference bundle C at tab 35.
Sorry, but volume.
Supplemental reference bundle volume C.
Tab 30.
Tab 35. So just to see what we're looking at, this is an email from Mr. Cahill, that's the BC signing it off. So one of the principles of PNID effectively, to Mr. Andrew, and only to Mr. Andrew. So obviously a document that Mr. Cahill thought that Mr. Andrew was going to look at. He's not simply being copied in as part of a range of people. You'll notice it attaches what is said to be a photo. So this might have thought itself raise some suspicions. See below copy of the letter received today. Obviously no explanation of where it's come from or suggested that it's for any particular settlement purpose. And if you go over the page, what is it? It's a photo of a letter from Professor Sage, Senior Advocate of Nigeria, who is FRN's potential expert at this stage, to FRN's leading counsel. And you'll see at the end of the first paragraph, I must confess that the ministry appears to be in a very difficult legal position. Moreover, Justice Belgore, that's PNID's expert statement, is quite formidable. Now, I just ask, would anyone struggle to understand the judge's finding that some of the documents were ones that no one could have thought were being provided to advance settlement? In what world could that document ever assist settlement? Now, unsurprisingly, Mr. Andrew was cross-examined at length about it. That's back in the core supplemental bundle, still in tab 8, and indeed the page we were looking at, 130. Just after the passage I was looking at, you'll see the bottom of page 86, there's reference to paragraph 23 of the statement of facts, and then reference to the Professor Sage to Mr. Chancellor letter, and you will see at page 87, line 19, Mr. Andrew says he certainly would have looked at it. Then following that at line 21, Mr. Howard puts, I think you'd agree that a potential expert advising the FRN of what he considers is the position in their case, that there's no conceivable reason for it to be disclosed. And Mr. Andrew suggests, well, there might have been some reason that was unconnected. And it's then put, well, there's no reason to say that they think they've got a duff case. There's absolutely no reason that that could be in FRN's interest, is there? And Mr. Andrew accepts that. There's then at the bottom of the page, page 88, lines 13 onwards, the fact that it's sent as a photograph. At line 18, it suggested it's self-evident, just seeing it, that it's been wholly improper. And he says it's been provided informally, which one might think is something of a euphemism. And Mr. Andrew says it's self-evident that it's wholly improper. Would you answer the question, please? And Mr. Andrew accepts that at least that document on its own, yes, would appear to have been wholly improper.
Yeah.
So there's no secret about what's being put here. The pleaded case, that it's apparent from the face of the documents that they could not have been properly provided, is put, and indeed Mr. Andrew has effectively accepted that that document on its own could not rationally be explained. And it was then put to him, as you might expect, over the page at 131, internal page 90.
Yeah.
From about line 12, again, Mr. Andrews seeks to say, well, look, you've got to look at this document in context. I can see why, if this was the only document I'd received, I would perhaps reach a different conclusion. What's the conclusion? That there might have been something improper, and I'd want an explanation for that because it contains legal advice and it appears to have been obtained by a photograph. Mr. Andrews says, and all of that you can see at the time. My point is very simple. At the time you could have been in no doubt whatsoever when you opened this that the document was being privileged document was being improperly obtained. You could be in no doubt about that at all. But Mr. Andrew doesn't accept that. But absolutely no doubt that that case has been well and truly put.
Well, when he says at line 14 now, I'd already received an explanation for why these documents were being shared. That's a reference to the settlement argument, is it?
It's a reference, yes, very
and
generally.
Mr. Howard says, well, you can't possibly have thought that this was being provided for that reason.
Yes.
And then he says, I would be speculating.
Yes, and that's where we got to, that in the end, he obviously couldn't explain how it could have been provided for settlement, so he had to then come up with increasingly wild speculations as to how it could possibly have formed part of it. And you see at page 92, line 7, it may be that the document had been provided to show that the hearing wasn't going to go ahead. And this was the best Mr. Andrew could do. He couldn't say he'd been given any reason for this document. So he was forced into absolute wild.
You're actually making this up as you go along.
Yes. And indeed that, if you get to a point where a document is obviously improper on its face, and all you can do is wildly speculate about highly implausible theories, you obviously have a duty to ask your client, well, actually, how do we have this document? But of course, we know that Mr. Andrew says he didn't do that. He was satisfied by these generic references to, oh, don't worry about it, it's all fine, it's practice in Nigeria. My Lord, I don't do this, obviously it's not for your lordships to form a view on the substance, but just the weight of the material explains why these were not marginal points that needed detailed reasoning in the judgment. To say that some of these documents were ones no one could have thought were properly provided was effectively conceded by Mr. Andrew. If you go, the second example I wanted to show your lordships is if you've got the supplementary reference bundle C to hand, tab 56. And I know, at least my Lord the Chancellor is well aware of this document. Your Lordship has asked me about it. But this is an email from one of Mr. Adebayo's assistants to Mr. Cahill, copied to Mr. Andrew and to Mr. Adebayo. sirs, please find attached as instructed. And then over the page in tab 57 is an internal email from the in-house lawyer, Mrs. Adelore, to leading counsel, Mr. Chancellor at SAN. And this is the email giving Mr. Chancellor instructions about what to do in response to P&ID's offer of 850 million. And the instructions are: propose a mediated review to get it under 500 million, and you may want to propose 400 million. And again, this is sent on the afternoon, it seems, of the 6th of May, and sometime later that day, sometime later the day that this letter's mysteriously appeared from some unknown source, a formal settlement offer of 400 million is sent to Mr. Andrew, but that's rejected in circumstances where there is no question that Mr. Andrew knows that 400 million is not the best and final position. And again, as my lord said, obviously not the sort of document you'd ever want to show to your opponent. Unsurprisingly, the subject of, again, heavy cross-examination. Just show your lordship a few extracts of that, still in the core supplemental bundle, tab 8, now page 136.
Yeah.
Internal page 112, line 12 onwards. The hypothetical is put to Mr. Andrew. Well, if your client tells you to try and you can settle for up to 500 million, but to try and get a lower figure, it would be wholly improper, wouldn't it?
Where are you reading from, sorry?
Sorry, line
18.
18. It would be wholly improper, wouldn't it, for you to make the other side's settlement offer of 250 million, but at the same time inform them that they're actually prepared to pay up to 500 million. That would be wholly improper, wouldn't it? And he accepts that unless the other side had given permission to do that. Of course, that's one might have thought, a rather implausible situation, because then what's the point of making the lower offer? But there we go. Over the page, internal page 114, line 24. Now, in fact, FRN did make a settlement offer of 400 million and you rejected it. Yes, and you rejected it in light of the knowledge from the leaked document that it was prepared to go above 400 million. That's right, isn't it? No, we rejected it. You rejected it with that knowledge. Do you accept you had that knowledge? I accept I had that knowledge, but the reason we rejected it was because we're prepared not to go below 850. But again, plainly put, that the settlement negotiations are being conducted in knowledge of the other side's position, which is plainly a use of the material. Mr.
And then, well, there's an answer there to the effect that well, he accepts what he was aware of, so he must clearly have read it.
Yes.
And then Mr. Hyatt goes back to his hypothetical example.
Yes.
And there's an answer at line 22, which seems to be some attempt to suggest why Nigeria might have been sending it to them.
It's another one of these speculations. And what's particularly interesting about this is that this was made up on the spot, because the witness statement said something completely different, which was that he thought it was being sent for the purposes of
Settlement.
conveying the offer quickly. That was the witness statement explanation. And you see that was challenged, internal page 117.
Yeah.
Mr. Howard quotes at the top of the page Mr. Andrews' witness statement, where he does have a clear recollection of receiving it. And he says, it seemed obvious to me that the letter of instruction had been provided voluntarily in order to convey FRN's offer to me as a matter of urgency, rather than having to wait formally. And so the explanation there is to urgently tell me, and then unsurprisingly, Mr. Howard challenges that over a number of questions, saying it completely undermined the offer. and then at page 118, line 12, makes the point that the urgency argument doesn't work because the offer was sent on the very same day. And you will see at the top of page 119, clear as a pikestaff, that what's going on is that those insiders are informing you there's more money to be had, so tipping you off, don't accept the 400 million. And so that case is squarely put, and indeed at the bottom of 119, plain thing is that your evidence that the message was to convey urgency was patently false. So again, that is top of page 120. So the explanation of your witness statement is patently false.
Yeah.
So all of that absolutely squarely put. And my lord, I know that my learned friend will say, well, look, you've cherry-picked examples. I would be very happy to go through many others. There are documents about lines of defence saying we'll have a discussion about potential lines of defence. There are emails that say, call me. There are emails that lower in the chain. The person sending them says, please tell me when you've got it so I can delete them, this email. There was a raft of material that was on its face, obviously not being provided for the purposes of settlement. And that is the context for the judge dealing in terse, but frankly acceptably terse terms with this purported explanation, because it's sufficient to have looked at the documents and on their face, no one could have thought what you're saying is the position.
Well, if it had really been the case that it was thought that they were being provided for the purpose of facilitating a settlement discussion, then there would be no earthly reason why that couldn't have been something that was dealt with in the witness statement from Mr. Quinn that referred to the documents. It wouldn't have been necessary to excise from the witness statements the unofficial documents.
Yes, although, my lord, bear in mind the Mr. Quinn's witness statement is dealing with actually an earlier bunch of documents which are really in the context of the contract coming into existence. So they're not settlement-related documents. It's effectively a continuing practice where, in relation to contract formation...
And Mr. Quinn died by this stage?
By
the stage of these negotiations in 2015?
Yes.
Yeah, okay.
Yes.
All right, bad point.
My lord, the third point that was fairly and squarely addressed during the cross-examination was the suggestion that Mr. Andrew thought that he didn't have a duty to do anything and that it was fine for these emails to simply continue flowing to him throughout the course of the arbitration. Because bear in mind, it's quite an unusual case. In most of the sort of family type cases, what happens is someone produces a bunch of documents that are relevant to the proceedings and the lawyers have to decide what to do. Here, there is a continuing provision of documents throughout the arbitration of immediate relevance to what is happening. So obviously there is a much more acute issue of, well, do I allow that to continue going on? It's not a question of how do I deal with what's already happened. It's a question of, well, what do I do about this continuing flow of privileged material that is of immediate relevance to what I am doing now? Now, that was fully challenged. In the core supplemental bundle, if my lords would go back to tab 7 and to page 102, my learned friend took you to this.
102.
To 102, yes. And you see internal page 154, line 23. That's put that you agree that there are core duties or principles which include acting with integrity and honesty. You accept that those apply to the solicitor as well. You've shown the BSB written standards, which my learned friend showed you, and undoubtedly say that privileged documents have to be returned unless the lawyer is satisfied that they have been properly obtained in the ordinary course of events. he's shown asked to read the relevant paragraphs, and so it's put to him page 155, line 23. So essentially, a barrister is required to make inquiries, and 155, line 23.
Yeah, gotcha.
Essentially, a barrister is required to make inquiries, and unless satisfied the document has been properly obtained, is required to return it unread. Do you see that? I see that. And if a client were to refuse to reveal the document, the barrister would be professionally embarrassed. I see that. And the solicitor's duties would essentially be the same. I'm not aware of the duties differing significantly. So he's shown the documents, he's told that they say you've got to make inquiries and you've got to return them if you're not satisfied. No suggestion he's saying that he thinks those are wrong or do not reflect the duties of a solicitor. To the contrary, he accepts positively, but he's not aware of solicitor's duties differing significantly in that regard. And then squarely put to him, page 156, line 21, now pursuant to all of this, so that's the professional duties that have just been addressed, I suggest to you that P&ID upon receipt should have promptly identified FRN and the tribunal. To put it neutrally, it was in receipt of material which might at the very least have been improperly provided, and that it was confidential and privileged and should have been returned to FRN. Do you agree? He doesn't agree. And so he's asked, well, do you really think it's the position that you're entitled to keep documents, make use of them, keep quiet, not let FRN know? Is that the position you adopt? And again, his answer to that is not, yes, that's fine. His answer is, I do not think I had a positive duty to return the documents. I think that in the circumstances that were explained to me, I did think there was an innocent motivation for these documents being shared. I was satisfied by that. So again, his explanation is, I had a good reason to have them. Not, even if I didn't have a good reason, I would have sat on them anyway.
I mean, the position is this, isn't it? That if, so far as whether it's a solicitor or a barrister, doesn't seem to me to make much difference really, because the duties are essentially the same.
Yes.
If a solicitor becomes aware that his client has obtained illicitly documents that are actually privileged documents at the other side, the first thing he has to do is to say to his client, you shouldn't have those documents, you must tell the other side you've got them and return them. And if the client says no, then the solicitor has to cease to act.
My lord, plainly and self-evidently that's right. The only thing I would add is that there is a first stage to that, which is to make the inquiries as to why the client has the documents.
Yeah, I mean, sorry, I
yes.
missed out a stage. I mean, the first thing you do is to try and find out why your client's got them. But if your client has got them, or rather a fortiori, if your client has got them by an illicit means, which seems to have been the case here, somebody within Nigerian camp leaking documents to P&ID,
yes, then
that's all the more reason why you need to say to your client, this is totally improper, you've got to hand these back.
Quite.
If what you find, which certainly I recall doing a case at the bar where my client had got privileged documents on the other side by mistake, which had been sent by mistake, then that's a different matter.
Different matter.
It's
a different matter. And
it's still the same result, though, which you can't retain the documents.
Yes.
Or whether the solicitor or the barrister can't continue to act knowing that his or her client is retaining documents which they shouldn't have.
Yes. The difference is, of course, the test you apply where they've been provided by ostensibly legitimate means. So, for instance, in disclosure, there is an obvious mistake threshold to conclude that they have not been provided with apparent authority. There's not been a waiver of privilege. Obviously, where they're not provided in the ordinary course, the question is quite different because that's not how privileged documents are expected to be provided. And that's all the guidance says. It says you make the inquiries, and unless you're satisfied that they have been properly provided in the ordinary course, you've got to return them. That's what the guidance says. It's self-evidently right, and it didn't need the judge to say anything more. But, my lord, I say that it's sort of two limbs. One is that is self-evidently the position, But secondly, that is what Mr. Andrew was largely accepting. If you go on, please, to tab 8, page 144. Sorry, tab 8, yes, page 144.
Before you leave this exchange,
Yes.
did you want to show us in tab 7, page 158, where Mr. Howard was asking what was the difficulty in disclosing to FRN that you would receive these documents? Why was there any difficulty in that if, as you say, it's all perfectly above board? And the answer was the difficulty would be that even if the motivation was innocent, as I believe it to be, these documents might not have been provided with the strict authority of the government to Mr. Adebayo.
My
The
Lord.
same might be true of the early documents, though.
My Lord, yes. I mean, in many ways, I'm showing you the edited highlights. I mean, there are many ways one can get to the conclusion from the cross that it was utterly indefensible what happened here. That is another one.
This shows that
Even on his own confession.
knew that he suspected that there wasn't authority of the government.
Yes.
Well, I'm not sure what more you need.
Because I'm quite.
Yes.
In other words, somebody's giving us these documents, but it's for an innocent motive, whatever that means.
Yes.
But they weren't being provided officially with the knowledge and consent of the person whose documents they were.
Yes. And my Lord, in a sense, it doesn't matter how one gets there, whether it's even on his own evidence or on the judge's rejection of that, the belief that there was a good reason. Plainly, the evidence compelled the conclusion that he knew he was not entitled to these documents. But I say Mr. Andrews' evidence also accepted that once you got there, he knew he had a duty to do something about it. And that's the point where there's really a criticism of the judge. It said, well, he didn't explain why it was indefensible not to return the documents, because it's all very complicated. There's conflicting law about
But
immigrant.
the cases we were shown, the Marco Pierre White case, was not about privileged documents. Was it?
No. And certainly the reasoning isn't about privileged
No,
documents.
I think I'm right in recollecting there were either the wife had his documents or vice versa, but they weren't privileged documents. So it wasn't.
Certainly that's not the way the case was being put. It was just being put as private information.
Because if it's privileged documents, then they're completely different.
And that must be right. And that's why I say whatever these niceties of these arguments about Chengiz and all of that, the judge's finding that the failure to return the documents was indefensible is so obviously a self-evident truth.
Yeah.
That it really didn't call for any more explanation.
Well, it might be said that if the judge had given even more reasons than he did give, Mr. Andrew would be in an even position than he is.
My Lord, it might well be said that.
And the judge it's interesting that the judge, because the judge says at various stages, doesn't he, that he's not making findings about absolutely everything, and there are bits that he doesn't really. There's some fairly disturbing matters that he doesn't actually deal with.
There are. I mean, I think he was, on any view, generous. I think we would perhaps say unnecessarily generous in confining himself to the bare minimum criticisms he needed to make.
Yeah.
He rightly averts to the fact there was a great deal more that came out, including, I'm sorry to say, a great deal more about Mr. Andrews' conduct, which no doubt will be a matter for others to look at.
You were going to show us something in day 8.
I was, I'm sorry. Tab 8,
4.
at page 144. And it's internal page 141, at line 15. So he says, questions, but basically your position was you just didn't need to inquire. And he said, I wouldn't say that. I would say I'd already inquired and obtained an explanation. The default position is that I have a strict duty of confidentiality as a solicitor in relation to the communications from my client to me. It would be different if I had suspected that something terrible was going on. So Mr. Andrews' own evidence is that, yes, I have a duty of confidentiality, but it's different if I have suspicions. And of course, the important point is the judge rejected his evidence that he thought they were being provided for settlement. And so he did have suspicions, certainly he knew they were privileged, he knew they were damaging, and he had no genuine belief that they were being provided legitimately. So even on his own evidence, he wasn't
If the judge rejects his evidence that the documents were somehow obtained for the settlement reasons or whatever.
Yes.
Which he does.
As untrue.
So the judge is rejecting that evidence. And on this answer, it's indefensible because apart from anything else, he didn't actually try to defend it.
Precisely. And well, that's the point I was really trying to get at. I may have taken a long route to get there. But the short point I wanted to make is that although Mr. Andrew now jumps up and down and says, well, I didn't get a detailed explanation of why it would be indefensible, he wasn't trying to defend sitting on his hands and getting a flow of privileged documents during the course of the arbitration if there was some suspicion about their provenance. So, my lord, that's what I wanted to show you from the cross. As I say, it's very much the edited highlights, but hopefully enough to give your lordships the confirmation that this was not a case where Mr. Andrew was short of an opportunity to say what he wanted to say for what worth it had. Closings. Can I just show your lordships very briefly a few passages from the written closings? And I mainly do so for this reason. There's no doubt at all what case was being advanced in closing. And nobody took any objection that what was being put to the judge was unfair, hadn't been put, was not open to the court to decide. And by nobody, of course I mean PNID, but also I mean Mr. Andrew. He's sitting there, he's read the written closings, he's an experienced litigator with his own leading counsel. If he thinks that someone is inviting the court to make damaging findings about him, which he hasn't had an opportunity to answer, he has the opportunity to, and he should object. Article 8 in the end requires a fair procedure, and that includes all of the opportunities available to the person. If Mr. Andrew chooses to sit on his hands and do nothing about it, he can't pop up after the judgment comes out and say, oh, well, no, that wasn't fairly being before the court. But my lords, the written closing is the core supplemental bundle at tab 15. Page 242. And I should say, this is the way this has been done is the core supplemental bundle has extract. The full version is in the reference bundle, but the bits I need I can take from the extract. Paragraph 3 could not be more squarely putting the case against Mr. Andrew. The second sorry part is PNID's own lawyers. As with the corrupted officials and legal advisors of FRN, so too was the integrity of Mr. Andrew and Mr. Burke compromised. They were offered life-changing sums of money contingent upon success in the claim, which induced them to look past evidence of blatant corruption, most obviously in the form of the FRN privileged documents, in the hope of reaching their promised pots of gold. They did so at the expense of their professional obligations. It's a cautionary tale of why lawyers are not permitted, subject to tightly defined exceptions, permitted to take personal stakes in their own cases. Their judgment was blinded by the prospect of riches beyond the dreams of avarice. Now that was the case put, that was the case the judge accepted by and large.
And yeah, I mean, that actually addresses the corruption point, doesn't it?
It does.
Because what's being said by Mr. Howard and your team there is that the corruption included the obtaining of the illicit documents.
And plainly it must have done. I mean, people weren't providing these documents out of charity. Now, of course, the judge didn't need to find who provided the documents, but on any view, they were being provided corruptly. They were being provided in breach of their duties, no doubt with some aim of benefiting. Now, who was corrupt? We don't know. Who did the corrupting? We don't know. But there's no doubt that the receipt of these documents is part of a corrupt process. It's corrupt in how it arises, and it's corrupt in its effect. It corrupted the arbitration. And if you go on, please, to page 250.
Yeah.
Paragraph 18, specifically as regards Mr. Andrew, case again very squarely put, second line. Unfortunately, the charade that he is a respectable, highly regarded and senior lawyer has crumbled to reveal an evasive and dishonest witness, motivation to lie, about halfway down, it said fundamentally he lied in his professed belief that these documents had been obtained legitimately. Truth is that Andrew had several billion reasons to withhold from the court what he knew about how the documents had been obtained, and indeed to withhold from FRN and the tribunal during the arbitration in breach of his professional duties, the fact that the documents were being provided to P&ID. So again, no doubt that the point about financial motivation was being relied upon. There's then a detailed criticism of Mr. Andrews' evidence, starting on around page 260. Bottom of the page, there's a heading, Mr. Andrews' best speculations for why some of the documents might have been provided. And you
So
get,
where's that?
sorry, just above paragraph 208,
Page?
260. And it's put that you've got the heading just above paragraph 208, best speculations. That's put at paragraph 208 that Mr. Andrew is trying to salvage his professional reputation. Paragraph 209, you will see that there is a detailed annex given as on a document by document basis as to why those explanations didn't work. And the punchline, paragraph 210, at bottom of the page, they are nothing more than that, i.e. speculations, and do not make sense on their own terms in any event. They are contrived and are falsely intended to mask the reality that it would have been obvious to those involved at the time that the documents were obtained as a result of corruption. So no doubt what is being put, and indeed just so you, my lords, have seen it, page 277 onwards, is then the detailed reasons why, by reference to the statement of facts, why Mr. Andrews' explanations were false in every respect. And so, for instance, if you see on page 279, sorry, that's a bad reference, page 281, you see reference to statement of facts, paragraph 40, which is what we've looked at, the Chancellor 400 million, 500 million letter, and then you see a detailed rebuttal of the evidence given in that regard. So no doubt, again, that Mr. Andrew understood that his explanations were being challenged root and branch. There's one point I should just make, because it is relied on, at least my learned friends' written submissions. If you go on, please, to tab 16, page 285.
Yeah.
Paragraph 154. This is P&ID's closing. Final point, FRN cross-examined Mr. Andrew at great length about the privileged documents. And you'll see it said, and questions may be asked as to whether they complied with their respective professional duties, although the court may consider it's not the right forum in which to make definitive findings in that regard. Now, just a few points about that. Firstly, on its face, that is accepting that the court may well make findings about it. It's a gentle nudge not to do it, but to say that it may consider it's not the right forum is a recognition that it's certainly on the table. Mr. Andrew tries to rely on this to say, well, I've been thrown under the bus at this stage. Now, the answers to that are numerous. One is, of course, the judge had heard Mr. Andrew's own explanations and no doubt took those into account in his evaluation. The second is that Mr. Andrew read this document. Mr. Andrew knew what was being said to the court. Mr. Andrew no doubt knew as an experienced litigator that when not even the party who would have an interest in defending his conduct felt able to do so, there was at least a very real risk that the judge was going to the same conclusion, and he did nothing. It wasn't for the judge to say, oh, Mr. Andrew, have you noticed that your company's legal team are no longer defending your honour? If he thought there was something that needed to be said to the judge and that P&ID were no longer willing to say, it was for him to do something about it. It's not the judge's job, he's got enough on his plate, it's not the judge's job to look out for very sophisticated lawyers and their interests.
I think over the page there are some defence, as it were, of Mr. Andrews put up briefly.
There is. There's a.
286.
I mean, largely what's being done is an attempt to say, well, even if Mr. Andrew behaved improperly, it wasn't in the specific respect that P&ID were trying to say would be the only legally relevant respect for a Section 68 challenge. So it was sort of confess and avoid. We can't really defend what he did, but what he did didn't affect the award. My lord, that's what I wanted to show you in terms of the what happened at trial. I can then take the grounds of appeal quite briefly. I'm going to do that out of order, starting with ground 4. And ground 4 is the challenge to the finding that Mr. Andrews' evidence about the documents being shared for settlement purposes was untrue. And the reason I take that first is because that's really the linchpin finding. Once the judge has rejected that, the whole house of cards comes tumbling down, because there's then no legitimate explanation, no possible legitimate explanation for what Mr. Andrew did. If I can just show your lordships the finding, it's in the judgment core bundle A, tab 4, page 124. Yes.
Page
124 has the relevant finding.
sorry.
And it's the final sentence of paragraph 214. I reject as untrue Mr. Andrews' oral evidence that the documents were shared as part of settlement discussions. Now, of course, that has to be seen in context. If you go back to page the previous page, 123, paragraph 210, the judge says that he's reviewed these internal documents and at least some were plainly subject to legal professional privilege. They were confidential and P&ID was not entitled to see them. The more relevant are identified in the course of this judgment, and indeed that includes things like the Professor Sage letter, the 400 million settlement letter. He says he's reviewed the documents, and at paragraph 213, he accepts there may have been limited occasions where documents were made available as a means of showing that Nigeria was doing something or was serious in what it was doing. But on other occasions, which must be, and indeed the judge later says are the majority of occasions, that was not the reason at all. No one who saw the document in question for P&ID, and that obviously is a category that includes Mr. Andrew, who did see the documents in question for P&ID, could have mistaken the latter type for the former. And so the judge's reasoning process is absolutely clear. I've looked at the documents, and at least some of them are so obviously not capable of being provided for settlement that Mr. Andrews' evidence that that is what he's thought cannot be true. That's the reasoning process. And it doesn't matter for these purposes, but it's a perfectly coherent and logical reasoning process. It's a perfectly understandable reasoning process. No one's in any doubt. And indeed, anyone who's seen the documents, it is entirely clear what the judge has in mind. And indeed, it is hard to see how the judge could sensibly have reached any other conclusion based on simply what is on the face of the documents. So that is the process of reasoning. And the only challenge to that finding is a reasons challenge. And my lords, we say, first and foremost, there is no obligation under Article 8 for Mr. Andrew to be given reasons for why his evidence has been accepted or rejected. Second, even if there were a requirement to give reasons, the reasons here were more than adequate. Even under Article 6, there is no duty to give detailed reasons, no duty to explain why a piece of evidence has been accepted or rejected. All that's needed is sufficient to show that the judge has considered the fundamental issues and how he's resolved them, and it is perfectly clear he has considered the issues. Were these documents that Mr. Andrew believed had been provided for settlement? And it's perfectly clear what he's decided they weren't, and it's perfectly clear why he's decided it, because having reviewed the documents on their face, they are not capable of being understood by anybody in that way. That is perfectly adequate reasoning.
Yeah.
Third and finally, even if there were a problem with adequacy of reasons, the answer was that Mr. Andrews should have asked for further reasons when he received the draft judgment. It's only the procedure as a whole that needs to be fair, and the procedure was fair in circumstances where Mr. Andrew had a mechanism and was given the opportunity to review the judgment from his personal perspective. His own choice not to take it is his own choice and does not indicate any deficit in the procedure itself. So for any or all of those reasons, we invite you to reject ground 4. That then takes me to ground 2, which is that the conduct in not returning the documents was indefensible. This is put both as a notice or warning challenge and as a reasons challenge. Now, the notice challenge is, even by the measures of this appeal, totally without merit. The breach of duty allegations were put fairly and squarely in cross, having been fully pleaded. If the contention is, which is what I think my own friend Skeleton is saying, is that the judge had to warn Mr. Andrew that there might be a finding that he had breached his duties, there is just no basis for that in the ECHR at all. There is no basis that you have to warn a witness that the judge might find the case that has been put to them has been proven. And indeed, it's hard to see why there would ever be a basis for any such duty as part of a right of meaningful participation in the proceedings. This seems to be linked to the fact that P&ID had abandoned its defence of Mr. Andrew by the time of closing. But that's, of course, something Mr. Andrew knew, and I've already made my submissions that he'd already had an opportunity to set out his position, and indeed he'd accepted that the position would have been different if, as the judge ultimately found, he had not had a genuine belief as to how the documents had been provided. The reasons challenge should also be rejected. Not going to repeat what I've said about the legal principles. The short point is that the finding here that the failure to put a stop to the provision of the documents, and that's ultimately what the judge says in paragraph 215, the decision not to put a stop to it, at least by informing Nigeria or immediately returning the documents, was indefensible, was is clear and adequately reasoned. It is clear on its face. It is not required under Article 8 or indeed under Article 6 for the judge to explain in detail why he found it indefensible. That's not, that's a level of detail that is not required. But in any event, in the circumstances of this case, that finding was more than adequately reasoned. As I say, Mr. Andrew had not sought to defend his conduct in these circumstances. He had accepted that it would have been different if he'd had a suspicion, as was effectively found by the judge. P&ID had not offered any defence for his conduct by closing, so there was no reason why anything more was required from P&ID's perspective. And frankly, there is no world in which a lawyer can, on a continuing basis, while they are acting as counsel, receive self-evidently privileged and indeed damaging documents belonging to the other party without any genuine belief that they're being properly provided and do absolutely nothing about it.
It goes back to the comment that I made, that the very least the lawyer has to do once he knows about it is to say to the client, you shouldn't have these, they have to be returned. And if the client says, no, I'm going to, if the client takes the attitude which Mr. Carhill and Mr. Murray seems to have taken, well, this is the sort of thing we take advantage of, which is paragraph, the end of 215, then the lawyer has to say, oh, I'm terribly sorry, I'm going to have to withdraw from the case.
Yes. And it really, there are some matters that are just so self-evident, particularly to someone like Mr. Andrew, who has professional
I mean,
advice.
what's seized on, I understand it by Mr. Wardell, is that in 215 in the second sentence, their decision not to put a stop to it, at least by informing Nigeria or immediately returning the documents they knew were received, is to say, well, Mr. Andrew couldn't have returned the documents to Nigeria without breaching his duty to P&ID as his client. It may be that the judge has misstated the extent of the duty on the lawyers as opposed to the obligations which the client had vis-a-vis material which was illicitly obtained. But the fact is that the conclusion that it was indefensible would still stand.
Well, absolutely. And that's the short answer to all of this. Whatever interesting arguments there might be if they've not been privileged, and we were looking at the duties in relation to confidential documents under Chengi, once you get to privileged documents flowing on a continuing basis to a lawyer who is involved in the litigation to which the decision to do nothing, not to try and put a stop to it, is indefensible. And nobody needs more of an explanation for why that is. If the judge has misstated the extent of the duty, that's a substance point and it can't be challenged on this appeal anyway. But in my submission, he hasn't. It is the lawyer's duty to do those things, just as it's the lawyer's duty to tell the court the truth. If the client prevents the lawyer doing what they are duty bound to do, then they have to cease acting. That doesn't change the fact that it is his duty to see that the documents are returned. And that's, of course, the way it's put in the bar standards guidance, is that it is, unless satisfied the document has been properly obtained, at once return the document. Now, that's his duty. If he can't do it, the answer is he has to walk away. And so the reasoned challenge should also be rejected. To the extent it's being suggested that the judge should have made some findings about the degree of culpability or the mental state of Mr. Andrew, completely unnecessary. Those are matters for the SDT, and those are matters that the SDT will have to form a view on. Was this blind eye conduct? Was it deliberate conduct with cynical motivation? Those are matters that, for the SDT, it's no part of a reasons challenge to this judgment. Next is ground 3, which is the question of financial motivation. And again, and that's again in paragraph 215, the reason that they acted in this way was because of the money they hoped to make. And there is both a notice challenge and a reasons challenge to that finding. Now, just stepping back and leaving the detail of this case to one side, the motivation for a witness to have done or not done something is always in play as part of the judge's evaluation of the facts. It's not an issue in and of itself. It is part of the fact-finding process. I mean, very most famously, of course, Lord Justice Robert Gough, as he then was, said in the Ocean Frost case, it's essential to test the credibility of witnesses by reference to the documents in the case, and also to pay particular regard to their motives and the overall probabilities. So it's always going to be in play. Whenever the truth of a witness's account is in play, their motives for doing or not doing the thing is always going to be fair game. And it would be absurd if a judge in every case where a witness's motivation has to be analysed, has to give some warning to the witness that that's what they might think about. And motivation was obviously particularly relevant in this case because it could be argued, as indeed P&ID did argue, at least in opening, that one starts from a presumption that legal professionals are inherently unlikely to have acted dishonestly. And one has to balance against that. Well, why might Mr. Andrew have so far fallen from the expectations of legal professionals? And the obvious answer is, as Mr. Howard repeatedly put it, he had billions of reasons to do so. Sad as that is. So when one comes to the notice allegations in this case, I say Article 8 certainly didn't require notice to be given of the motivation issue. That is sort of the detail of how the case is going to be presented, which Gray says doesn't need to be given to a witness anyway. It's just inherently the sort of thing that is in play. But in this case, it was expressly pleaded. My Lord saw in the reply, we pleaded he had a financial interest in the outcome of the arbitration, dealt with in witness evidence, and he's cross-examined about it. So absolutely notice was given about the relevance of his financial interest. Now, I don't accept that having explored what his interest was, it was in fact necessary to put to him that his misconduct was motivated by the financial motive. Indeed, one might think that is a piece of meaningless formalism, because if you put to Mr. Andrew, your misconduct was motivated by your financial interest, his only answer could be, well, I didn't commit any misconduct, so it wasn't motivated by anything. It would be given that he's denying he did anything wrong, he can hardly explain what his wrongdoing was motivated by.
Isn't the point really dealt with by Mr. Howard's cross-examination? Because his cross-examination is basically criticising Mr. Andrew's conduct on a number of fronts, and then saying, well, you were doing all these things, and the reason was because you were going to get along.
And my Lord, that was done, certainly in the context of at least one document.
Not specifically have said, therefore, you know,
my Lord, that's the bit I'm
plus
dealing
y
with.
equals z. But a bit difficult to see. It could be said that Mr. Andrew wasn't on notice as to what was really being alleged.
And I think that's the height of how this point is put, that it wasn't squarely put to him, you did A because B. And that just can't be necessary. It would be a meaningless question. All the building blocks of it had been put, the link had been put in that he was asked in terms, you were interested in the documents and you had a financial interest. And Mr. Andrew had already said, in the context of whether he was motivated to lie in the proceedings, my professional reputation is more important to me than money. So what more could he possibly have said? The judge had heard everything that he could say on this topic. And tellingly, my learned friends don't suggest there is a single thing that Mr. Andrew could have said about his financial motivation that he hadn't already said. In terms of inadequacy of reasons, again, I don't repeat the submissions that there was no obligation to give reasons, and this really is getting into the realm of detailed reasons for accepting or rejecting evidence. The financial motive is itself part of the factual reasoning process, why he's accepted or rejected evidence as a whole. And you're talking then about reasons for reasons for reasons. But fundamentally, this is the sort of point where the judge just has to form a view. He knows what Mr. Andrews' conduct was, he knows what Mr. Andrews' financial interest was, and there's no process of reasoning to be given. It is a view formed of the totality of the evidence. The specific points put in my own friend's skeleton paragraph 76, the judge did not point to any evidence suggesting that Mr. Andrew had in fact been swayed by financial interest. What does that mean? He was never going to point, Mr. Andrew wasn't going to have written a letter saying, I've deceived the tribunal because I hope to make lots of money. Never required for a judge to point to a specific piece of evidence that demonstrates the point. The judge is entitled to evaluate the totality of the evidence. The other point made in my learned friend's skeleton is that they say in paragraph 77 that Mr. Andrew did not have a financial interest during the course of the arbitration beyond his usual fees. Well, that is just wrong.
Even Mr. Andrews' own evidence, albeit rather reluctantly, was that he was expecting to get paid some sort of bonus or whatever. And
some substantial amount.
There was cavilling about the amount of the percentage, but he never said, oh, I never thought I was going to get paid anything at all. I was just doing this arbitration out of the kindness of my heart.
My pro bono contribution, no, plainly not. And one needs to remember that paragraph 215 is framed in terms of the money they hoped to make. It is not a reference to a legally binding interest. It is simply a reference to the money they hoped to make. And Mr. Andrew accepted he hoped to make a substantial amount of money during the arbitration, whether through this bonus or through coming in through Lismore as funder.
Yeah.
All the criticisms of that are without merit. Ground 5 is the challenge to the finding in paragraph 216 that Mr. Andrew didn't pay particular attention to the documents or didn't read some or all of them in full. Only challenge to that is a reasons challenge. Again, not going to repeat what I've said about why that sort of finding is not one that would ever require reasons for reasons under Article 8. But this is plainly, even under common law standards, the sort of thing where a judge is entitled simply to give a summary view of that sort of evidence. The fraudster's conventional, I didn't read the incriminating email type defence is one that very often is dealt with summarily. The judge has seen the documents, they've heard the witness give evidence, and they simply say, well, I don't believe it. It's not a question of, like it is with expert reports, engaging in some intellectual debate, simply forming a view on whether they believed what the witness was saying, and the judge didn't. No doubt in circumstances where he'd rejected other evidence. So there really wasn't anything more for the judge to say. Mr. Andrew was making these self-serving denials that he'd looked at these documents in the face of things saying, call me and we'll discuss this later. And the judge was perfectly entitled to say, don't believe it. Didn't need to say anything more. That then takes me to ground 1, which I accept is a different point. This is the complaint about paragraph 592, the end note on page 208.
Yeah.
And I really dealt with this in my submissions yesterday. It's of course very important to emphasise what paragraph 592 was. It is avowedly part of an end note in a judgment. Where are you least likely to find some new radical finding of very serious misconduct than a wrap-up end note in what is a long and detailed judgment? paragraph 592 doesn't refer to anyone specifically. It refers to a combination of examples of what some individuals have done. It is obvious to any reasonable reader that this is simply a collective reference to the findings that have been made in the judgment, throughout the judgment, and no reasonable reader would have understood this as making a specific new finding beyond the matters already addressed in the judgment.
Yeah.
Also got to be read, of course, in the context of paragraph 593, if this had been a finding of corruption in the sense of bribery, obviously, when the judge comes to deal with Mr. Andrews specifically, he would not have referred simply to Nigeria's internal legal documents. The involvement in bribery would have been something that obviously had to be referred as well. And that is no doubt why Mr. Andrew didn't think the reference to corruption in paragraph 592 merited any complaint when he, and it seems Mr. Treverton Jones, King's Counsel, reviewed the draft judgment. And my lords will recall, although there is a complaint about the greed reference in paragraph 592 in the original grounds of appeal, there was no complaint about the corruption finding in paragraph 592 in the original grounds of appeal put before the judge. And my lord, obviously there's a limit to how far I can take that, but what I say is it demonstrates that a reasonable reader of the judgment as a whole would not think that the word corruption was doing something inappropriate in that context. So against that background, 3 points. First, we say Article 8 really doesn't have any relevance to this paragraph. It's a generic end note that's not making any finding specifically about Mr. Andrew additional to what is elsewhere in the judgment. Second, in any event, the judge was perfectly entitled to include Mr. Andrew within the scope of a general criticism about the use of corruption in this case. Corruption is not simply bribery, it's not coterminous with bribery, as indeed my lords can see from the judgment. If you go back to paragraph 11 on page 85, the judge says, before this court, as a challenge to the award, Nigeria makes allegations of bribery, corruption and perjury, demonstrating that corruption is clearly not that simply bribery and nothing more. And on the judge's findings, Mr. Andrew, in an indefensible breach of his professional duties and in expectation of significant personal gain, was part of the fraudulent procurement of the award in a manner which utterly compromised being words the judge uses, the arbitral process. He did so by receiving and retaining privileged documents which were being deliberately provided by individuals, whoever they may have been, who had no authority to do so and were therefore acting in breach of their duties. And that is corrupt behaviour. It is fairly described as corrupt. And indeed, Mr. Wardell was, in my submission, effectively driven to accept that yesterday.
Well, it was a question that actually my Lord Justice Jeremy Baker put about dishonesty. What's the difference between dishonesty and corruption in this context?
Yes, and in many ways, the moniker of corruption is generally used where there is some financial interest in the
I was about to
dishonesty.
say, of course, that one of the reasons why you might say in this context that corruption was the right noun, not just dishonesty, is because of the financial motivation of the vast amounts of money that would have been made if the Section 68 challenge had failed.
Yeah. And so there was certainly no need whatever for the judge to carve out Mr. Andrew from this end note. It's perfectly clear what it means. It's a perfectly fair criticism. and it would be entirely wrong, we submit, for paragraph 592 to be excised from the judgment. As I say, Mr. Wardell in submissions yesterday suggested there was some problem with including Mr. Andrew within the scope of the corruption finding, because I think he said the case hadn't been put or decided on the basis that Mr. Andrew in fact used the documents, but that, with respect, is unreal. Use had been specifically pleaded. I showed your lordship that in the reply. It said, in breach of professional duties, Mr. Andrew and Mr. Burke positively used the documents. The judge had found that Mr. Andrew decided not to put a stop to the use of the documents, not to put a stop to it, because of the money he hoped to make. And that can only, if you've got a motivation for doing it, can only be because some use is being made of the documents. He rejected the suggestion that Mr. Andrew hadn't paid attention to them, and he found at paragraph 217 that P&ID, which obviously includes Mr. Andrew in the context of those passages, was using it to track Nigeria's consideration of the merits, strategy and settlement throughout the arbitration. And we saw that Mr. Andrew accepted that he had knowledge of this 400, 500 million issue at a time he was making decisions about rejecting or accepting settlement. So to the extent that that is a relevant point, it couldn't be clearer that Mr. Andrew was criticised on the basis that he was continued to receive and look at these documents, knowing that he wasn't entitled to do so, because he hoped that it would benefit him personally. And that's a perfectly fairly put case. And of course, third and finally, if there was any issue with this paragraph, Mr. Andrew had a remedy. He could have raised it when he had the draft judgment. And again, a process unfair simply because a person does not take an opportunity which they have asked for and been given. He asked to be permitted to show the document to his counsel because his counsel sometimes made submissions before handing down, and was given that opportunity and didn't take it.
Given the seriousness of the allegation as developed by Mr. Wardell yesterday, the failure to raise it with the judge is rather difficult to comprehend.
It is. The explanation I suggest...
There's a sort of curious... it may be that Mr. Ford is going to help us a bit on this, but it's one of the things that I haven't really got clear in my mind, because I don't think anybody's shown us yet the letter that Mr. Andrew wrote to the judge.
Well, it may be worth showing you, Lordship, actually, in core supplemental bundle. Yeah. Because I sort of summarised it there, because it's quite interesting, because it does specifically refer to the possibility of making submissions on the draft judgment.
Yes.
It's in core supplemental bundle tab 19, I think.
Yeah.
Yeah, page 343.
Yes.
And so you'll see this is sent, I think, the day after the draft judgment is circulated. Very much like to speak to leading counsel who's been advising me in relation to allegations of professional misconduct. Treverton J, who is an expert in that field. It's my understanding he sometimes makes submissions between dissemination of draft judgment and handing down in relation to draft findings of professional misconduct. If your lordship permits, I'd like to be able to share the draft judgment so that he can advise me as to whether any submissions ought properly to be made to your lordship prior to hand down on Monday in relation to the contents of the draft judgment. Now then you have Mr. Andrews' evidence that, having received the judge's response, that wasn't to be taken as an indication that an application would be appropriate. He decided not to make an application. He's of course not waived privilege in the advice. I can't draw any adverse inferences from that, but he certainly can't tell you I was advised that it would be inappropriate to do so. What we know is he had the opportunity, he had professional advice, and all he's told you is that given the judge's indication, he didn't make an application.
Yeah, I mean, what actually happened is that Mark Howard wrote an email saying to the judge, you shouldn't let Mr. Andrew disseminate the judgment in this way, relying on what Miss Justice Foxon had said at an earlier stage in the case, which in turn relied on the Court of Appeal and Graham Borre.
Yes.
And then the judge actually, the
Did allow
judge's
it.
reaction was that Mr. Andrew could show the judgment to Mr.
My lord, I know you've already said it, so but I adopt as my submission the observation plainly to any competent lawyer. This is not, however, to be taken. Sorry, it's tab 21, page 346, where the judge says this is, however, not to be taken as an indication that an application on behalf of Mr. Andrew would be appropriate. Is no more than neutral.
Well, if one sees the context of that as being Mr. Andrew's email followed by Mr. Howard's challenge,
Yes.
one can understand why the judge was not prepared to go further than he did, because he may have had in mind that if there were a challenge,
Quite.
then there might be a basis for Mr. Howard on behalf of Nigeria being able to say, well, that's not an appropriate challenge for the following reasons.
He's just saying I'm not prejudging the submissions that Mr. Howard has made and may have relevance if an
Not shutting the door.
No, and not even, I would say, discouraging.
No, quite.
It's simply saying that allowing you to think about it is no indication one way or the other as to whether or not it would be the right thing to do. And that, we say, is fatal to any suggestion that the process as a whole was unfair. And the best explanation for it, why nothing was done about this paragraph, the best explanation, maybe it was tactical, that it was thought better off not getting any more said, and then jumping up and down about it afterwards. But if that's not the explanation, the best explanation would be that, correctly understood, that paragraph 592 was no more than a reference to the use and receipt of Nigeria's internal legal documents. And one gets a hint of that from the draft grounds of appeal at the time, which said, it is understood that paragraph 592 is intended in part as a critical reference to the conduct of Mr. Andrew in the receipt and use of Nigeria's internal legal documents. So all of a piece, they read it correctly and therefore didn't see a need to challenge it.
Yeah.
But whatever the explanation, the problem was not in the process. My lords, that deals with all the grounds, entirely coincidentally at 1 o'clock. That just leaves me some very brief submissions after lunch to make on discretionary reasons and the balancing of the Article 6 aspect, before I'll hand over to Mr. Ford, who I think will be about 20 minutes on Section 68(4) and extension of time.
So you should, between you, finish by about 3:15?
Certain, I'd have thought by 3.
Okay, that gives Mr. Wardell time to...
Yes. Thank you.
Okay, good. Right, 2 o'clock then, please.
Court rise.